Greetings, dear colleagues, candidate, and the public. Today, on the 18th of January 2025, the advisory group of experts gathered in full to interview the candidate for the position of the judge of the Constitutional Court of Ukraine, Dovhal Serhii Volodymyrovich. In particular, members of the advisory group of experts are present: the Secretary, Madam Maureen O'Connor, the members of the advisory group of experts, Yaroslav Romanyuk, Mr. Aleš Zalar, Mr. Vasil Shakun, and the member of the advisory group of experts, Madam Hanna Sukotska, and me, the chair of the group, Oksana Vasilchenko. The interview is also attended by deputy members of the AGE, Mr. Vitaly Makinchuk, Mr. Marek Zubik, Mr. Richard Barrett, Mr. Volodymyr Kuzmenko. I should note that we are working in a shelter, so in the event of the air raid alert, the interview will continue without interruption. I would also like to remind you that the interview is being recorded and broadcast live on the AGE resources and the CCU website. Therefore, I would like to draw the attention of AGE members and the candidate to restrict the use of sensitive data and restricted information on air. If it is necessary to discuss such issues, the AGA will restrict the broadcast for this time. We are now ready to begin, so I will now hand over to Maureen O'Connor, Secretary of the AGE, for a brief introduction of the candidate and to remind the interview schedule. Madam Maureen, you're welcome. The floor is yours.
Thank you very much, Madam Chairman. Greetings, good afternoon, dear colleagues, and everyone who is watching this program today. As our chair has already said, the advisory group of experts will now interview the candidate Serhii Dovhal. Let me remind you that the opportunity to interview is a mandatory stage in the assessment of candidates as part of the evaluation of their competence with the criterion of high moral qualities. The time limit for the interview is approximately 1 hour, and the time limit for answering each question is no more than 3 minutes. Traditionally, we would ask all candidates to be concise and to answer clearly, to the point, to the question that is asked. At the end of the interview, the candidate may make a short closing statement of no more than 5 minutes. We would also note that while processing the materials on the candidate Dovhal, the AGE sent questions for written explanations so that the candidate had an opportunity to prepare for this interview and to provide answers. So now we have with us the candidate for the position of Judge of the Constitutional Court of Ukraine, Serhii Dovhal, who was admitted to the competitive selection by the Competition Commission under the President of Ukraine. Mr. Dovhal has been the founder and director of Jur Business Consulting Law Company since 2005. Also in 2011, he received a certificate of the right to practice law and has been practicing law ever since then. Mr. Dovhal, if you would like to add anything at this time regarding who you are and your credentials, you may do so now, up to 3 minutes.
Microphone, please. Thank you. You have mentioned everything, nothing to add.
Задавати питання.
Please, the colleagues, let's ask the questions. I guess I will start. On September the 7th, 2024, you filed a declaration of a candidate for the position of a judge of the CCU for 2023. Later, during the assessment by the advisory group of the high moral qualities of candidates for the position of judge of the CCU, you submitted a notice of significant changes in your property status dated November the 3rd, 2024. What significant changes have occurred in your property status that necessitated your submission of the notification dated November the 3rd, 2024? What was the reason for the need to submit the third declaration on December the 7th, 2024? May I answer? Well, in fact, no changes took place. The submission of the following declarations and changes in the declaration were related to the discrepancies in my previous declaration, and also because not all information that subject to be reflected was reflected in it. That's why it doesn't refer. I mean, it is because due to lack of experience to fill out such declarations. So, in fact, only in December 2024, I submitted the proper, in its form, declaration. Comparing your declaration dated September the 7th, 2024, and the last published December the 7th, 2024, we can see a number of discrepancies that boil down to failure to declare in the first declaration. Exactly. Mainly, mainly. Leased apartment of 72.1 square meters in Kiev, a 65.6 square meters apartment in Izum, Kharkiv region, owned by your wife, a 900 square meters land plot in Nikopol, Dnipro region, owned by your wife. Motorcycle Java, made in 1987, Opel car made in 2006, Opel Movano car um, made in 2004, owned by your wife, a 2010 BMW X5 owned by your wife, a 2012 Peugeot car owned by your wife, your membership in the NGO Healthy Nation, Healthy Country, and the National Bar Association of Ukraine. How can you explain so many discrepancies? This is not the first time. Yes, yes, this is the essence of my reply, stating that the last declaration has been completed fully and correctly. The first declaration you referred to, and I admit this, unfortunately, not all information has been reflected in it. So I kindly ask the advisory group of experts take into consideration the last declaration, because it has been properly filled out and it is in line with the current legislation. The first declaration, and I have already explained this per your request, that indeed it is not in full, and that's due to me not knowing the technical moments of filling in the declaration. I have never been the civil servant, so I just didn't have the experience to fill it in. That's why, unfortunately, I failed to reflect all information in the first declaration. But the last declaration is um, thorough and proper. So please consider that one. I see. In section 11, income including gifts of the 2023 declarations filed on the September the 7th, 2024 and December the 7th, 2024, you indicate income from independent professional activity in the amount of 360,000 hryvnias. At the same time, in this declaration for 2023 filed on March the 12th, 2024 as a candidate for the position of a judge of the High Anti-Corruption Court, the amount of such income was 240,000 hryvnias. How can you explain this? I have also explained this in the written answers. The correct is 360,000, 240,000. That is my miscalculation. I see. Do you confirm that you don't have the official income in the declaration for 2023? No, I do not confirm. 360,000, we have just talked about this. I see. Also, in the notice of significant changes in property status dated November the 3rd, 2024, you indicated a one-time expense of 156,000 hryvnias. That is rent for an apartment in Kiev. Yes. Why is this information missing from the declarations filed on September the 7th, 2024 and December the 7th, 2024? The answer is the same. I didn't know where this information is to be indicated. That's why, and I will read myself. The last declaration has full information about me, and yes, it was a rent for 1 year, and I have indicated this in this declaration. Okay, if some of those explanations could be clear, then let's move on. In the declaration of a candidate for the position of judge of High Anti-Corruption Court for 2023, dated March the 12th, 2024, you indicated a 2017 Mercedes-Benz. However, this information is absent from the declarations for 2023, filed on September the 7th, 2024, and December the 7th, 2024. How do you explain these discrepancies? It's not about a toy, right? No, of course it's not a toy. And as far as I remember, it has been indicated in the last declaration. Indeed, it was purchased by me and registered by me. Although I may be wrong, but I have provided the answer with proper evidence on this car. I cannot remember about the owner. If we can reference my answer with all the documents that I have attached to it. Do you want to answer something more? No, nothing additionally. I see. Well, according to the information available to the advisory group, your mother owned a Land Rover Range Rover made in 2012 between July the 7th, 2021 and June 29th, 2024. You were a proper user of the vehicle, meaning that you were entitled to use it legally. However, there is no information on the right of use in the 2023 declarations filed on September the 7th, 2024 and December the 7th, 2024. How can you explain this? I have also answered this question. I did have the right to use it, but I wasn't using it. That's why I did not indicate it on the right of use in my declaration. I will pass the floor now to my colleague, Mr. Alish Zeller.
Good day to the candidate. I have a question which concerns some amounts of money and declarations you filed. According to the State Register of Individuals, in 2023, your wife received income in the amount of approximately 234,000 hryvnias, which included 224,000 hryvnias from the sale of a real estate and 10,320 hryvnias of social benefits. However, this information is not available in the 2023 declarations filed on 7th September 2024 and on 7th December 2024. How can you explain this?
I have already explained these questions when answering in written answers to your questions. The specified social payment, that was something that is given at the childbirth. And as for not indicating them in the declaration, This is my mistake, but in the last declaration, I did include this information.
You didn't. So,
На жаль,
Unfortunately, I didn't.
yeah, okay. The next question. You are the owner of an apartment with a total area of 192 endpoint square meters in Odessa, 129 square meters. And in value, according to your declaration for 2023, this apartment supposed to be valued 1 million Ukrainian hryvnias. In the declaration of you as a candidate for the position of a judge of the Kharkiv Court appeal for 2022, you indicated the value of the same apartment at 2,400,000 hryvnias. So there's a big discrepancy between 1 million and 2.4 million hryvnias. How you can explain these differences? And when and under what circumstances did you find and buy this apartment?
Thank you for your question. I have already provided my written explanations, but I will repeat myself. The evaluation on 2,400,000 hryvnias, this is my personal evaluation of this property in accordance with the market price before the war began. And I will again speak about lack of experience, that I had lack of experience and I didn't know the rules to fill in the declaration correctly. And at the moment when I was filling it in, I didn't know which values to be specified. That's why 2,400,000 is the cost of this apartment in my subjective point of view before the war. I ask to consider the last specified cost of this apartment that is indicated also in the purchase sale agreement, and that is 1 million hryvnias. This is the cost that was specified in the agreement. It was decided by the parties to the agreement. It is in line with the evaluation cost specified by the notary when concluding the agreement. So this is the cost that is the right one, the correct one. By the way, I have the original of the agreement, and if necessary, I can provide it to be considered by the advisory group of experts. And there, the copy of it I have attached to my answer, and there it was specified 1 million hryvnias.
Can you explain under what circumstances did you find and buy this apartment?
так,
Yes, of course. I found it on the OLX website. I have met the seller. I have checked the documents, went to Odessa. I took a look at this apartment, and then I met with the seller and the owners in Kyiv and concluded the agreement. I have paid for the apartment during this meeting, and there is the application from the sellers that they got to the money and they have no claims against me.
Apartment is seized as part of criminal proceedings.
так, безумовно.
Yes, of course, I know the initiator of this criminal proceeding is me. If necessary, I can find, I got the abstract from the Register of Pre-Trial Investigation. I was the applicant in this criminal proceeding because after purchase of this apartment, certain circumstances occurred which I wanted to be checked and verified by the law enforcement agencies. And then the criminal proceeding, the criminal case was open. Unfortunately, I'm no litigant in this criminal proceeding, even though I am the claimant in this criminal proceeding. And the further the further destiny of this criminal proceeding is not known to me. As far as I know, certain circumstances were identified, but they have nothing to do with me, and I am no litigant to this criminal proceeding.
And with respect to the imposition of arrest on this apartment, in fact, I learned about this from your questions and your requests to provide documents and answers to your questions. Before that, I did not take part in any investigative procedures during the pretrial investigation or during the trial proceeding. So this arrest was imposed on the apartment without my participation, and I was not notified about that.
Yes, so the arrest ruling shows that you purchased this apartment for 60,000 US dollars in cash. How can you comment on this?
Yes, I also saw this information in your request to provide answers to the questions and documents. I commented on this in writing, and I would like to repeat that I did not know why the court specified this value. I also do not know what was the reason why the investigator or the prosecutor filed a motion on imposition of the arrest. Because as far as I understand, this information was specified in those documents, because the court takes this information from materials of the pretrial investigation. As far as I remember, during the only questioning with the investigator while submitting the claim on entry of information about the criminal offense was not provided by me.
Yeah, but the arrest warrant quotes that you was interrogated as a witness.
Yes, yes. Yes, that was the only time when I was interrogated, when I was filing the report on entry of information into the register of pretrial investigation. That was the only time. And I did not provide this information about this amount to the investigator. Later on, I tried several times to get acquainted with the materials of this criminal proceeding, but as a claimant and not a participant, not the effective party, I was not allowed to do that. So I do not know where they took this amount from in the criminal proceeding and what was the reason why the prosecutor or investigator specified this amount.
So you think that they simply invent this, and because they are clearly referring to your statement that you transferred 60,000 US dollar in cash?
I cannot comment on that, and I cannot undermine our law enforcement bodies. In the context of your made-up phrase, maybe made up, maybe they have some other grounds to specify that. Maybe it was just lack of professionalism of law enforcement bodies. I will not insist on any specific answer regarding this.
So what does this mean? That you are denying that you delivered 60,000 US dollars in cash?
Yes, yes, of course.
Pay in cash at all?
No, I paid in cash in the amount that is specified in the sale and purchase agreement. That was 1 million hryvnias.
Explain the source of funds for the purchase of this property, please.
Yes, I provided explanations several times regarding this. I have a large number of documents. During my last response, among other things, I asked the AGE whether I should provide all of these documents. First of all, in 2019, as I specified, these funds were received by me as profit during my attorney's activities. In 2019, all accumulated funds were invested by me according to sale and purchase agreements for equipment. I have them in original copies here right now. I concluded these agreements with two legal entities, Electro Group and LLC Electro Leasing. Back then, under the first agreement dated October 5 of 2019, I bought equipment for the amount of $60,000. I have original copies of the sale and purchase agreement. I have specifications. I have transfer and acceptance certificates. I can provide them to you so that you could look through all of these agreements. The second agreement is dated October 5 of 2019, also for the amount of $60,000. The third agreement dated April 6 of 2019 for $16,000, and the fourth agreement is dated April 6 of 2019 as well for the amount of $16,000 according to the NBU's currency exchange rate as of the agreement date. According to these agreements, I invested into these legal entities in total, that was $154,000, which was used to buy equipment for electrical vehicles chargers. They were located in Kiev and all over Ukraine. These legal entities subsequently were liquidated. As far as I know, these were some fraud schemes. Some criminal cases are ongoing. I'm the affected person under these criminal cases, but I do not know about the destiny of these criminal cases. But these charging stations for electrical vehicles were sold by me later on to individual entrepreneur Palshin Yuri. I have over 150 agreements. I also have original copies here, and I can provide them to the AGE. I also ask you in writing whether I should provide all of them, because this is quite a substantial number of documents. I have not received the answer regarding that. All of these charging stations, which I bought under these investment agreements, were sold to this person. And this person paid this money to me during 2 years. And I have bank statements from my account. I also have original copies of all the documents regarding receipt of these funds by me. Unfortunately, I spent $154,000 for the purchase of these charging stations, but later on I sold them with a discount, and that was slightly more than $100,000. And according to these agreements that were concluded, these funds were transferred to two bank accounts that I have. All bank statements show that the buyer completed these payments in 2022. So I received the full payment from the buyer. As of the moment of receipt, that was over $100,000. And later on, I used these funds to buy some property, including the purchase of this apartment. So all of these funds are confirmed with respective documents. And if necessary, I can provide these documents to the AGE. I can make copies, I can notarize and provide them to you to attach to my case. Thank you.
Thank you for this extensive explanation about the source of funds. Let me just remind you on important information we received that from the State Register of Individuals, that your total income for the year, for the period of 1998 to 2024 amounted to only 260,000 hryvnias. But let me continue now with the next question. On last day of March 2016, the High Council of Justice issued a decision refusing to submission to the President of Ukraine on your appointment as a judge of the Nikopol City District Court of Dnepropetrovsk region. How can you comment on this decision?
Again, if you allow, I would like to repeat that I provided quite a substantive answer to this question in order not to take too much time of the AGE. I will very briefly now summarize the following. In my opinion, even though lots of time has passed since then, I still believe that the High Council of Justice did not understand the essence of the issue. The HQCJ understood it. They provided a recommendation for me as being appointed for the position of the judge, but the HCJ unfortunately did not understand the essence of this problem. In fact, they paid attention to the letter of judges of Nikopol court without checking how justified those facts were. So, further on, I filed a claim with the High Administrative Court on question of this decision, but unfortunately my claim was not satisfied.
Yes, and in this decision, the High Council of Justice states that you participated in the court hearing of the Nikopol City District Court as a representative acting on the basis of a power of attorney dated 13th of May 2008, issued by the principal who died on 7th August 2006. How can you comment on the fact that the power of attorney was issued 2 years after the principal's death?
I'm sorry, I do not know about this fact. No deceased clients. I've never had any deceased clients, and this is the first time when I hear that from you now.
You hear from me the first time. Have you read the decision of the High Council of Justice?
Yes, I read it, and I did not see this fact there.
Thank you. No further questions.
Dear colleagues, do you have any other questions to the candidate? If there are no questions, dear candidate, you have up to 5 minutes to say concluding remarks. Thank you, dear advisory group of experts. Again, I would like to express my gratitude for inviting me to the interview. It's a huge pleasure for me to be in this procedure, to take part in this competition. I really hope that you will give me a chance to work for the benefit of our country. And I hope and I count on your positive decision. Thank you. Thank you, Serhii, for your answers. Right now, I'm hereby declaring interview with a candidate for the position of the judge of the CCU, Dovhal Serhii, as over.